Hi, everyone. Good morning. Welcome to our presentation here at Squire Patton Boggs, talking about California's Workplace Violence Prevention Program. My name is Michael Kelly. I'm a partner in the San Francisco office, as you can tell by the Transamerica building looming over my shoulder. I'm in the Labor and Employment Group, and along with my colleagues here in California and around the country, workplace violence is one of the issues that we are regularly helping our clients deal with. And coming up, there are new compliance obligations that the state of California has created. Put a little bit of perspective on this, I wanted to give a sense of what the issue of workplace violence looks like statistically. Unfortunately, we're in a little bit of a black hole in terms of reliable statistics simply because of the COVID pandemic and what that did to individuals' normal experience of going into work and what that was. The best studied data right now is from the 5-year period that ends in 2019. I know that's 5 years ago, but it's really the last category of well-studied statistics that gives us a sense of what the trends were in workplace violence. As much as we hear about stories in the media about homicides at work, the truth is our workplaces are safer today than they were, say, back in 1994. In 1994, with a smaller workforce, the US had a peak of over 1,000 workplace homicides. In 2019, that was down to just 454, so a 58% decline. So measured in terms of homicides, the workplace has gotten safer. Looking in that same 5-year period at non-fatal violent incidents at work, and this comes from crime statistics, so it really probably underreports the frequency simply because many workplace incidents don't result in a criminal prosecution or a criminal charge being made. But in that 5-year span, 2014 to 2019, there were 2015 to 19, there were 1.3 million non-fatal workplace violent incidents that led to a touch with the criminal justice system. Now, what does that translate to? It translates to 8 per 1,000 employees. And these numbers, too, can be a little bit exaggerated because they'll include occupational groups like corrections officers, where it's 149.1 corrections officers impacted by violence during that period per 1,000. Most of us, thankfully, are in much safer occupations. We can also track workplace violence having different impacts based on gender. For example, in calendar year 2019, 5.1 per 10,000 women were treated for injuries in the workplace resulting from violence, compared to 2.3 per 10,000 for men. Women suffered 65% of the 37,210 reported injuries from hitting, kicking, and being beaten at work. Interestingly, though, men suffered 85% of the non-fatal intentional shootings in the workplace. And having spent the weekend looking at statistics like that, I kept pausing and thinking, well, how many people are unintentionally shot at work? And the reality is our workplaces, as safe as they are, continue to be places of hazard. The 2 bar charts that I have on this slide represent, from the Bureau of Labor Statistics, the top 5 groups by selected occupational group for first workplace homicides in 2020, which was, of course, a COVID year. And then the second chart is the non-fatal workplace intentional injuries. I picked these up mostly to point out to everybody on the call, most of us probably fitting into the category of management in Bureau of Labor Statistics analysis. And we are the third most likely group to experience a homicide behind sales and retail and transportation and material moving. In management, we are playing roles that have a higher degree of danger. Similarly, the non-fatal group, management is well service employees, but we still make the top 5. So as we go along and are talking about the compliance obligations that California has created by Senate Bill 553, if it's any consolation, one of the primary beneficiaries of this are probably people like you and me who are in the management ranks in our companies. So let's talk about Senate Bill 553. This is a law that augments what used to be the way that employers would deal with or look at workplace violence. And that was under the federal and the California OSHA General Duty Clause. The General Duty Clause is simply the part of the federal and state workplace safety laws that say that employers have an obligation to provide a workplace free of known hazards likely to cause death or serious injury. And so under that standard, if you had a convenience store, you knew that there was a risk of it being robbed at night, early in the morning, and therefore you had to have greater safety measures to protect your personnel from that kind of violence. Hospitals and other healthcare facilities have had their own healthcare anti-violence standards imposed by OSHA. But for most of us, this was something that we simply considered, to the extent we did overtly consider it, as perhaps a bullet point or two in an injury illness prevention plan. Senate Bill 553 changes that. Under the new law, there is an obligation to adopt a written workplace violence prevention plan. And the law is very detailed in what goes into that plan. The statute also requires annual training, and we're going to talk a lot more about that training in a few minutes. It requires keeping a violent incident log, and this is a log that you would maintain for any violent incident, which is going to have a broad definition. So it'll be different than your usual OSHA injury log. Incidents may well qualify for this Senate Bill 553 log that would not go into your OSHA log because no one was actually hurt. You can anticipate that starting in July, if an OSHA inspector comes to your work site to do a standard inspection, they'll be asking to see your workplace violence prevention plan. It's simply something that it's another box for them to tick on their form, and so important for you to make sure that you have adopted a plan and are taking the affirmative steps that you promise you will take through that document. One thing that's interesting about Senate Bill 553 is while it requires employers, substantially all employers in the state, to act immediately, it is simultaneously dictating that Cal OSHA has to adopt its own workplace violence standards by no later than December 31st, 2026. So what we can expect in the coming 18 months is Cal OSHA is going to be looking closely at what employers do, what works and what doesn't, and they will adopt a standard that everyone will have to fall into line with. But not wanting to pass a law acknowledging there was a problem and then have the state wait 18 months to start addressing it, Senate Bill 553 puts the onus on employers to start addressing it immediately. So who does this apply to? It applies to every employer in California, unless you are part of the Department of Corrections or a law enforcement agency. Hopefully, you'd already be doing what you need to do. or you are covered by existing healthcare standard. So if there's already a plan that you're required to have in place, you don't need to do a new one. The third exception is a more interesting one and may apply to some of your facilities or to your companies. It's any location that is not open to the public where fewer than 10 employees work at a given time. Now, what does that mean, locations not open to the public? If you're in an office building and for somebody to come up to your floor, they need to pass through a security checkpoint and only authorized visitors are allowed to come up. That would perhaps be your experience if you had come to the Squire office in Los Angeles or San Francisco, then that would not qualify as a location open to the public. In contrast, take our Palo Alto office where the door opens right from the street, but you do need to have a swipe card, probably doesn't qualify. Probably would not qualify because, again, doesn't seem to be open to the public, even though it doesn't have that kind of robust security. It is interesting, though, that if you have 10 employees working in the facility at a given time, it doesn't matter whether you're closed or not. I suppose that reflects that somebody in the Senate decided once you get 10 employees together, it's a lot more likely that one of them is going to be mad and do something they shouldn't do. And so you need to have a plan for that. It's 10 employees working at a given time as opposed to a head count of 10. So if you have some employees who are assigned to a location, but they don't normally report to that location, either because they're in the field or they're hybrid, and you can look and objectively conclude that you don't have 10 employees there at a given time, then you should fall within the exemption. If it's a close call, I would make sure I did some survey, have some documentation around to back up that conclusion just in case you get asked about it by OSHA. You are not responsible for preparing workplace violence plans under this law for individuals who work remotely from a location of their choosing outside of your control. So the people you have working from home, the people who are working at third-party sites and you do not have control over those sites, they would not trigger a plan requirement for you. Now let's talk about the kind of conduct that the state is defining as workplace violence. It means acts, but it also means threats of violence that occurs in a place of employment. It's a threat or use of physical force against an employee that results in or has a high likelihood of resulting in injury, psychological trauma, or stress, regardless of whether the employee suffers an injury or not. And this is why I was saying that you may find yourself obligated to log things even though nobody was hurt. And likewise, it's not just actually getting punched, but it's somebody waving their fist and menacing, something that constitutes a threat. Now, note, though, that these are threats or the use of physical force. So other kinds of threats, threats that might be more employment related, bullying, that sort of thing, depending on the nature of the threat, may or may not qualify under workplace violence. And so you'll want to look very closely at these definitions as you're preparing your logs. Also, just note, any incident involving a threat or use of a firearm or other dangerous weapon, and the statute very specifically says, including the use of common objects as weapons, regardless of whether the employee sustains an injury. So again, brandishing a stapler at somebody may well fit the same criteria here as a semi-automatic pistol. And while it's not so clear in the statute, the materials that Cal OSHA has released in support of this initiative does have some references to getting bitten by animals. So animal tax ought to be something that you include as well. There are 4 categories of violence based on who is perpetrating it or who done it. These categories will be important for you to understand because they will impact how you log. They may also impact and just prompt you to be thinking about the threats you face in your work group and how you want to address them. The type 1 category is someone who has no legitimate business at the work site. Uh, that would prototypically be, people who simply come on the premises because they're burglars, that sort of thief. If you are an organization that may attract attention from animal rights activists, those activists, if they come to your work site, will again be type 1. That would be a type 1 incident. Type 2 incidents are ones that involve customers, clients, or visitors. And I think the intent of the statute there is to recognize formal visitors. In a colloquial sense, anybody who comes to your work site is visiting. But as to distinguish from the type 1 and the type 2 would be your official visitors. I would put your vendors who may perpetrate violence or threats in this type 2 category. Type 3 are present or former employees, supervisors, or managers. So that's all of the people you know well, your folks coming in. And then type 4 are individuals who have a known personal relationship with somebody at the work site, but who does not work there. Typically, that's going to be family members, significant others, that sort of thing. Now, working through these with a client, we use the example of my wife. For those of you who don't know, I met Michelle at the firm 30 odd years ago, and she doesn't work for the firm anymore. So if she came to the office, she would be someone who had no legitimate business reason to be here. So if she came to throw something at me, say a dish, because I forgot to empty the dishwasher and put my dirty breakfast dishes in with the clean ones, which embarrassingly I do sometimes do, she comes to throw the dish at me, she would be type 1 violence category. But she did work for the firm about 30 years ago, so she would also technically be a type 3 person. And she's my wife, so she has a no personal relationship, so she would be a type 4. The question was asked, when you categorize this in your log, would you put 1, 3, 4, or would you just pick one, or would you make 4 different lines in the entry? The problem when these sorts of very detailed requirements are created by assembly action is we have very little guidance. I would say common sense is each incident should have 1 line, and you should characterize the individual by that which seems the most predominant or most accurate description of them. Given that Michelle hasn't been with the firm for 30 years and that she was throwing the dish at me because of my inadequacies as helping to take care of the kitchen, which goes to our known personal relationship, I would call it type 4. But again, at least for now, until OSHA issues its guidance in 2026, use your best common sense as you fill this out. But just remember, you will need to know these categories as you're logging things. So as I said, you're going to have 4 obligations that you really need to be thinking about on a regular and ongoing basis. Initially, making your workplace violence prevention plan, then conducting training according to the plan, and you will need to revisit that training regularly. You'll need to review other compliance, and finally, periodically sit down and update the plan or document that you sat down and decided the plan didn't need to be updated. So let's talk about the plan. Our recommendation is that you start out by inventorying what you have. Most clients already have policies governing things like harassment and bullying. You don't need to completely reinvent the wheel with your workplace violence prevention plan. What you'd like to do is, where you already have things in place, integrate them into the workplace violence plan. But again, be mindful that not every act of harassment is an act of workplace violence, but some of them might be. Not every act of bullying is an act of workplace violence, but some might be. Uh, Look at what you already have in place for reporting procedures, such as hotlines. One of the things that the SB 533 references several times is the importance of making sure that employees feel like they can report acts of workplace violence without fear of retaliation. So for those of you who have currently in place ethics hotlines or other ways of anonymously reporting things, integrating that into your workplace violence prevention plan will let you take advantage of infrastructure that you've already put in place. Also look at the other procedures that you have. Procedures for things like earthquakes and fires. All across the country, we know that buildings have fire prevention plans and fire evacuation plans. Here in California, we add earthquakes to that category. But think about how those plans operate in the context of something catastrophic like an active shooter. And none of us want to spend a lot of time thinking about that, because it's sort of like estate planning. You really don't want to contemplate that. But honestly, that's exactly what this kind of law is asking employers to do, is to give some thought to how you're going to manage that. And starting with things you already have will make your job easier. Now, Cal OSHA has also prepared a model plan for you. If you look at the slide, you'll see in parentheses, I have Cal OSHA template violence. That's the Google search that will land you on the template. You can download and just start cutting and pasting, filling in the boxes, deleting things that aren't relevant, adding things that are relevant. But more than anything else, it will enable you to spot gaps as you're looking at that and you think, yeah, gosh, I did not think of that. Something that they emphasize is thinking about what other employers you might need to coordinate with as part of your workplace violence prevention plan. You may have a factory where you have third parties coming in and out regularly to maintain your equipment. Those individuals ought to be trained and familiar with your program. You may share in your building a lobby or other common space, and you want to think about how you're going to handle something and talk to your neighbor about how they would handle it, so that you can coordinate. And a very specific item in the Cal OSHA model is prompting you to think about, are there third parties? You'll want to identify who will be responsible for implementation, and a lot of commentators suggest that you do it by title, so that it is clear that when you switch facility managers, you don't need to go change the plan. I recommend that you do it by title and by name, because at the end of the day, if there is an incident and something is happening, and step one in the plan is to call the facility manager, the last thing you want is somebody fumbling for a phone number or trying to figure out who is the facility manager here, as opposed to just having that number handy because they've got it right there in the plan. And so I recommend, and you'll see that the California model template suggests that you put the individual's name and their phone number in there. I would include the title so that you're backstopped if you switch facility managers and don't roll out a new plan immediately. I also think that if an individual is designated as responsible under the plan, one of their first duties when they get promoted into that role should be to make sure they have gone through the plan and that it is updated for them. Again, the last thing you want is for there to have been an incident at your facility. Uh, OSHA comes out immediately, and the first thing they do is they say, we want to see the facility manager who's identified as being responsible for the plan. And the facility manager who's got all of 2 days under their belt comes forward and says, oh, that would be me. And they start asking them questions. And the answer is, well, I haven't actually reviewed the plan yet. I was going to do it over the weekend. So again, mindful of these being active protective documents as opposed to just box ticking exercises, I would suggest including name and contact information. Another question that many clients are grappling with right now is whether you should have a separate plan or incorporate it as part of your injury and illness prevention program. The statute clearly allows you to add this as an add-on to your IIPP. The advantage of doing it that way is if you already have a good IIPP and employees are trained on how to access it and your infrastructure, your intranet, whatever you use to make it available to employees is up and running, adding this to it lets you build on to that and is one less new item that you have to do. In contrast, you would have to set up a new link on your intranet site, add the new document, and so now you've got two things you have to keep track of rather than one. The contra position is if you have an incident and somebody from Cal OSHA comes out and they ask you for your workplace violence prevention plan, and it is a separate document, you can give them your workplace violence prevention plan, and that's all they'll have, that's all they wanted, that's all they'll look at. If it is incorporated into your IIPP, you'll give them the entire document, and there's a greater risk that somebody from Cal OSHA might start idly thumbing through the other pages of your document, the IIPP portion, and while your workplace violence plan passes muster, something else doesn't. Lawyers have a tendency, as you know from working with us, to try to give government investigators as few things to look at as possible. To me, this is balancing administrative convenience and getting it done quickly and well with trying to separate documents so that you don't have to worry about them, the state looking into them. Another question that comes up is whether you should have a separate worksite plan or a company-wide plan, or at least a statewide plan for all of your locations in California. Take Squire Patton Boggs, for example. We have 3 offices, one in LA, one in Palo Alto, and one in San Francisco. In deciding whether we would have 1 plan or 3 plans, the place to start is to ask how different are the risks. The reality is for us, the risks in the 3 facilities are about the same. In contrast, if you have 16 retail operations in California and 1 warehouse, the risks in a retail operation may be very different than warehouse risk. Among other things, your retail operations are open to the public and you've got a whole different set of issues. You may be leasing those spaces rather than owning them. There may be on-site security at those facilities that you don't have at the warehouse. So start by asking how different are the risks. But if they're very similar, then having a statewide or company-wide plan may be more efficient for you. Same question for how different are the procedures. If the procedures are the same in each location, then having 1 plan would work just fine for you. Another aspect of the statute is it specifically requires input from employees in development and implementation. Now, part of the root of that, I think it's very clear reading the statute, is recognition that some of the employers that are dealing with this will have collective bargaining representatives for their employees. They'll be unionized. And SB 533 wants to be very clear that it is making room, reserving a place at the table for the unions in these conversations. But for most of us who are non-union, the question is, what does that input from employees look like? If you have a safety committee, this can become another item on the safety committee agenda. Other commentators have suggested that simply putting up a suggestion box and training employees on using the suggestion box, or setting aside an email address for safety suggestions, would also be adequate ways, barring whatever Cal OSHA tells us we end up needing to do. My practice has been to suggest that a small selected group from a cross-section of employees sit down together and go over the plan before it is made final, so that you can document a stronger, more interactive employee input. Again, just to make sure that you can demonstrate to the state that you took seriously that requirement. I already mentioned determining whether you need to coordinate with other employers. That can also include custodial services who might come on your premises, staffing agencies if you're regularly using third-party employees. All of those are individuals that you need to potentially consider. The plan also should detail how employees should make reports. Make sure that you have an explicit promise that there will be protection from retaliation, and describe how you will respond. Now, in reading the statute, kind of have to put your head in two places. One is sort of long-term concerns about recurring threats or recurring acts of violence that employees that happen systemically. It might be something to do with a retail space. It might have to do with any number of points of contact with the public, or with vendors, not to mention coworkers. At the same time, there will also be incidents that require immediate, urgent reaction. Somebody is having just a temper tantrum and is throwing something, all the way up to an active shooter situation. Contemplating in your plan in advance how employees are supposed to respond. And I happen to be at one end of a horseshoe-shaped office, if somebody comes in the outside door on my side of the horseshoe and is wielding a weapon, how do I contact everybody else in the office, or at least contact one person in the office who will then take up the responsibility for letting everybody else know what's going on and what they're supposed to do? So that's the kind of thing that lawyers can't help you figure out what will actually work for your workplace, but we can tell you that that's the kind of thing that the state appears to be looking for in your workplace violence prevention plan. You will have ongoing obligations to review the plan annually, or when a new risk or deficiency is identified, or following an incident. And so after every incident, you should plan on doing a review and asking yourself, did the plan work? Did it not work? Is there something that we should change based on what we learned from what just happened? Compliance review is a little different. This is something to make sure, especially physical or engineering safeguards are still in place. It's all well and good to say that we're going to monitor the safety of the facility by having spotlights in the parking lot to make sure that it's well lit. Well, as soon as those light bulbs have burned out or been shot out or somebody threw a rock and knocked them out, then you're no longer following through on your commitments about the physical safeguards. So somebody needs to be identified in the plan who will be responsible for circulating and making sure that the physical safeguards that are part of your plan are still in place. Likewise, verifying that systems will still work. If you decide that you're going to have a particular system to notify employees in the event of an incident of violence, I have been advising a university on this, and they have a campus, quite literally, and need to notify students and employees. And so they have some very robust procedures already in place. But you do need to test those from time to time to make sure that the text messages are getting out or the radio announcements are getting out, that sort of thing. And so building into your plan what your commitment is to doing that is something that the state will be looking for as they review workplace violence prevention plans. Training, this is a little different than what most of us are used to in the HR space. We've all gotten used to California telling us that we have to do 2 hours of interactive training every 2 years and within 6 months of bringing on new managers in the harassment space. Now we know we need to do 1 hour of training for non-supervisory personnel. This training is different in that all that the law says is that you have to train your employees. It doesn't say how, it doesn't say how long. And so having meetings, online trainings, circulating PowerPoints, kind of everything is available to you in terms of tools to use, and there's no specific tool that you're required to use. One thing that's clear is that employees should get trained in their primary language. If you have a multilingual workforce and you know their employees who primarily do their business, they talk to each other, supervisors give them instructions in another language, you should plan on training them on these safety issues in that same language. In terms of length, content, and mode, effectiveness is going to be your standard, not ticking a box because the state said that it had to be interactive, and so that means live or online. You have a variety of methods available. Use what works well for your company. It also applies to all employees working at the site. Now, that starts out as a pretty easy idea because you've got 15 or 20 people assigned to the office, and so you start with those 15 or 20 people. But you may have individuals who are employees who come to the site and work periodically. Here at Squire Patton Boggs, it might be an associate from our Arizona office who comes over to work on a case for a week. It could be somebody from another country who comes and is doing a few months in the office, becoming more familiar with US legal practice as opposed to China or Japan. Those individuals can't fall through the cracks. You need to have some mechanism in place to provide appropriate training for them as well. And again, this is an obligation for annual training and whenever a new threat is identified. So annual training and whenever a new threat is identified. So lots of record keeping for HR. You'll need to keep a record of how you've trained everybody, verifying that you're training them. And if a new threat happens, you start all over again. You start all over again. There are some very specific elements that you need to include in the training. Some of them might seem self-evident, but the SB 553 is pointed about this. One is how to get a copy of the plan and participate in development and implementation. That goes back to my comment about maybe making sure that you have a suggestion box or some email channel so you are directly soliciting and so that you can demonstrate to the state if they inspect your plan that you have invited participation in certain ways. Getting a copy of the plan, it may be, for most employers, it's probably keeping it on an intranet site. The state is frustrated with employer intranet sites simply because during COVID, so much information got moved over to intranet sites that the state now feels like important things can get buried. So I would recommend as a best practice, periodically sending out, maybe quarterly, maybe twice a year, reminders to individuals about the fact that there is a plan, that they can make suggestions to it, and send them a link to how they can get it. So again, you can show to the state if you get investigated, either simply as a regular investigation or, God forbid, after violence incident, that you were proactively trying to keep employees informed about the plan. Like any good SB 553 has a lot of definitions, and those definitions, including the categories that I talked about and the definitions of the covered conduct, those should all be covered in the plan. How to make a report. Also training on hazards specific to the work site and corrective measures that have been implemented, as well as how to get help and respond to violence. And training people on how to respond to violence is not necessarily in many of our wheelhouses. Exactly when you should run, when you should hide, or when you should fight back. There are law enforcement personnel, a lot of community police departments are willing to assist with training like this. And it's probably a good idea to reach out to your local law enforcement if you especially are in a suburb where they are often more responsive than in big cities, just so they're familiar with you and you're familiar with them, because that can be an important element in your workplace violence prevention. I'm sitting here in my office with a glass wall between me and the hallway, which is great to let light into the inner core of the building, which the architects think is a great feature. I have a wonderful stand-up desk, and as I've been working on workplace violence programs, I realized I have no place to hide. So the thing is, what you want is you want employees to assess their situation and think about it in advance before there's an incident, rather than while there's somebody walking down the hall with a firearm. You also need to train employees about the log and about the fact that you will be maintaining a log and their right to access the log. And that's an important consideration as we talk about what you're going to put into your workplace violence incident log. And then the last thing is that you get feedback on the training so that you can continue to make it more effective. What that ought to look like is something like a questionnaire at the end of the training, much like we do with continuing legal education or other programs that we put on. But getting feedback is an official part of your requirements under the statute. So now let's talk about record keeping, everybody's favorite activity. The violent incident log, you're looking and saying, okay, date, time, and location, that seems pretty easy and obvious. A detailed description, that can be a little bit more cumbersome because you may have 3 or 4 witnesses, each of whom has their own version of this. But you're going to try to come to the best description of the incident. And then the outcome or consequences. And that's a combination of, so was the threat carried out or it wasn't carried out? Did somebody come on our premises who was uninvited and caused a problem? What was the exact problem that they caused? But then in addition to log, what, if anything, you're going to do differently, or what action you took in terms of consequences for that incident. As I mentioned, you will need to make sure you include the category, whether it's a 1, 2, 3, 4, based on who performed it, who done it. You need to retain the log for 5 years. But this is the interesting thing, and think about it as you're making the log. You are to omit personal information in the log. So for example, the incident that would happen with my wife coming and throwing a plate at me, you wouldn't say, Michelle came on the premises at 10:15 and threw a plate at Michael. You would say, a partner's wife came on the premises and threw a plate at her spouse, or maybe even more generic, a partner's spouse threw a plate at them, so you don't even have gender pronouns in the description. The idea is that this log really is not the official report of the incident. It is just a summary of what happens at your company. It is an accessible summary, and so the personal information gets deleted from it. But that means that if something happens, you will want to make sure that you have a separate file where you have the rest of the story with all of the detail that you would keep as a regular HR document, not as the log. So as a log, it wouldn't be available to everybody. It would be available to everybody, but the rest of the details would not. Um, all employees, all employees have access to review the log within 15 calendar days of asking. And so again, keeping that log current and up to date, you don't want to have 16 post-it notes with various incidents stuck around your desk and somebody comes in and asks for the log and then you have to take 2 weeks to have to fill them all in. The training records you only need to retain for 1 year as opposed to 5 years for the log, but honestly, I put those training records kind of in the same category as the logs. I don't see that it hurts you to keep them for longer. And if there is an incident, being able to go back and show your compliance and who attended the training is going to be better for you than having thrown that away and just saying, well, trust me, everybody got trained. So before we get to the CLE credit slide, and I realized the lawyers were all just frantically getting ready to start to write down the code. I wanted to take a moment and talk about, from an HR perspective, some of the things that this is going to call on you to think about and be more aware of. For example, what are the triggers for workplace violence among employees? Usually employee workplace violence, layoffs and terminations are a huge stressor, and they can be a trigger. Disciplinary write-ups or being put on performance improvement plans, again, can cause a lot of stress, both between you and the employee and also between the employee and their supervisor or coworkers. Other conflicts with coworkers and just perceived unfairness. As you are involved in layoffs or you're reviewing bad behavior reports, poor performance information, those are things that you should be thinking about and asking yourself, is this a situation where this can escalate? And then the question is, what do we do as an employer in the event that we think something could escalate? Those are the calls from clients that I think every one of us in the labor practice hate most. The easiest thing for us to do is to tell you, well, hire a security guard, bring somebody to the premises. We know that costs money and you have to triage this. At the same time, none of us wants to be the one who got it wrong and falsely reassured you, oh, don't worry, nothing's going to happen, when none of us, including you who know these employees much better than we do, really knows the answer. Bringing a security guard on the premises during a period of peak threat is definitely an option. Our experience is that it is better to bring on security guards who are typically off-duty police rather than just a security guard. Regular security guards without law enforcement power have a certain role in some workplace settings. But if you are concerned that somebody, a recently terminated employee, a family member, maybe divorcing spouses, and there could be an incident, you're better off having an off-duty cop there, because even though they're off-duty, they still have arrest powers, which a traditional security guard who isn't law enforcement doesn't have. And really the last thing you want to have is something escalating with the security guard trying to intervene, and you still end up waiting while it's escalating for the police to come and actually detain the individual. So if you have a situation that is bad enough that you think you should bring somebody on the premises for a little while, we recommend that you try to bring on an off-duty police officer. That requires some homework and advanced planning because, again, when that happens and somebody has gotten a threat at work, 16 other things will be going on during your day. So already knowing a reputable local security company who can supply what you need is a good thing. So doing some homework now as you're preparing your plan will stand you in good stead. Hopefully, you won't actually call on this expertise, but if you need to, it's good to know it and have it in your pocket. Personal life of our employees is also a source of great stress and can end up manifesting itself in workplace violence. Um, I've referenced several times the risk of domestic violence spilling over into the workplace. Traditionally, in HR, it's been our approach that we want to know less about what's going on in employees' personal lives because that knowledge imputed to us just seems to get us into trouble with allegations of unfair treatment or discrimination. In the context of the risk of workplace violence, in training employees, telling them if you're concerned that something is going on in your personal life that could spill over, here's who you should tell so we can assess that and take appropriate actions. It's probably a meaningful thing for you to be doing. Substance abuse, mental illness, deaths in people's family, all of these kind of events. And it's not just the employee's substance abuse, but potentially the substance abuse of a family member, which is going to put them under a lot more stress and increase the risk that, given a bad performance evaluation, they're going to react in a extra harsh way. And these, I think, are the kind of things that, as an employer, as HR teams looking at compliance with this law, will hopefully elevate your compliance over and above just ticking a box and writing a policy which you put in a drawer and get out once a year, and making it into something that will hopefully make your workplaces materially safer. If you'll let me pause for just a second, one question came in. If you have questions, we do have a few minutes to cover them, and so you can pop them into the Q&A box down in the lower right of your screen. Yeah, so a question was asked about confirming that if you control access from the public, meaning that all entrances from the outside have access badge requirements, then you would be exempted from the plan. So a couple of things. First, remember, if you have 10 or more people who regularly work, the public access issue doesn't apply. You will need to have a plan. But if you have a small work site, so it's less than 10 people, and the public doesn't come into your work site, then as the law is currently written, it does not appear that you will be required to have a plan. This could change in 2026, but as it stands right now, that would be a non-public work site. If you're in a bit of an in-between situation where you have fewer than 10, so the non-public public distinction matters, but you frequently have people from outside coming in. You regularly host receptions, you do other things where you open yourself up, then you're probably going to fall into a gray area and it may behoove you to adopt a plan. But if you've got a small facility and the public doesn't come in and out of it, they can't just open the doors, and you don't have any kind of regular stream of public visitors, then I would say that you will be outside the requirements as they currently stand. The next question was, if a former employee came on site and the incident happened, do you treat it as a type 4 or type 1 because a former employee doesn't have a legitimate business interest at the work site? I think that former employee incident I would categorize as a type 3. I think that's where the former employees were. I think type 4 would be people who have a personal non-business relationship with you. But that would be how I would categorize it. I tend to think of the category 1 incidents as ones where basically you did not know this person in any way before they arrived. And so that would be the burglar, that would be the strangers who are showing up to demonstrate because of animal testing or some issue like that. That covers the questions that we've been asked. In terms of continuing legal education credit, for those of you who require them, This program is approved for 1.0-hour general in California. Soon after today's session, you'll receive an email with a certificate of attendance to complete, an email back to my colleague, Robin Halligan. Her email address is there on the screen. And please make sure to add the code PREVENT528. And one last question was asked about what is considered public. And for example, would access by what I would characterize as delivery people or vendors, I would not call that public. UPS drivers, FedEx, the US Post Office, that's a different category of visitor. And so I would not consider that to be open to the public. But again, right now we have a very vague statement in the statute. We do not have regulations that are specifically plumbing and defining that. So if it changes, if we get more FAQs from the state or better guidance on that particular point, we will be sure to post that to our employment law. I believe we call it Employment Law Worldview. It's the Squire Employment Law blog. So feel free to subscribe to that if you would like. With that, thank you very much for your time this morning. Any of the attorneys in our practice here in California will be happy to help you. For those of you who are outside of California, feel free to reach out to us and we can help you get things squared away here in our state. So thank you very much. Take care.